Good evening, everyone. A warm welcome to all the participants who have joined us today. I, Anjali Chauhan, Member Executive of SCBA and Vice President of Youth Bar Association, formally welcome you all to this webinar on mediation. The topic for today's discussion is role of negotiating party in mediation. We have with us Senior Advocate Rakesh Khanna, sir, to discuss on this topic. He is a practicing advocate and mediator in the Supreme Court of India. Sir was appointed as an ASG of the Supreme Court of India and has also served as the President of SCBA. We are glad to have you with Sir. Now, without any further delay, I request Khanna sir to kindly begin the session. Thank you, sir. Please, sir.
My sister Anjali Chauhan, Member Executive Supreme Court Bar Association and Vice President of the Youth Bar Association of India. Sanpreet Singh ji, President, Youth Bar Association. My esteemed brother and sisters, student colleagues, future budding lawyers.
Thank you, sir.
In this series of lectures, so far you people have understood the concept of mediation. Mediation, as you all have understood by now, is a voluntary, party-centered and structured negotiation process where a neutral third party assists the parties in amicably resolving their disputes by using specialized communication and negotiation techniques. In mediation, parties retain the right to decide for themselves whether to settle the dispute and the terms of any settlement. Even though the mediator facilitates their communication and negotiation, the parties always retain control over the outcome of the dispute. So in the whole process of mediation, it is the parties who are before the mediation process, in the mediation process, with the mediator, they have a very, very important role. As you have also understood by now, mediation is a voluntary process. Here, parties retain the right to decide for themselves whether to settle a dispute, on what terms they want to settle the dispute. Even in court-referred mediations, there is no binding on the parties to arrive at a settlement in a particular way. In this mediation, what the parties are required is to settle the terms of settlement of their own. They have the right to self-determine. The self-determination by the parties is an essential element of the mediation process. It results into settlement created by the parties themselves and is therefore acceptable to them. The parties have ultimate control over the outcome of the mediation. Any party may withdraw from mediation proceedings at any stage before its termination and without assigning any reasons. As I said, and as you have been told yesterday by Mr. G.M. Sharma, mediation is by and large a party-centered negotiation process. The parties and not the neutral mediator are the focal points of the mediation process. Mediation encourages the active and direct participation of the parties in the resolution of their own disputes. Though the mediators advocates, and other participants in the process also have active role in the mediation, the parties play the key role in the mediation process. They are actively encouraged to explain the factual background of the dispute, identify issues and underlying interests, generate options for agreement to make final decision regarding the settlement. As I said, mediation is an informal process. In the mediation, the essence is an assisted negotiation process. Mediation addresses both factual as well as legal issues and underlying cause of the dispute. Mediation is broadly focused on the facts, law, and underlying interest of the parties, such as personal, business, commercial, family, social, community interests. The goal of mediation is to find out a mutually acceptable solution and adequately and legitimately satisfy the need, desire, and interest of the parties. You can say in this whole process, the role of the parties is the focal point of the whole process. It is for them, they have to decide the process, they have to decide the terms of the settlement, they have to decide how they will proceed. A mediator only facilitates in formulating their issues, they assist them in understanding the issues, understanding the fallouts of the negotiations, understand them, what if they will not settle the issues, what will be the implications, what will be the time they will take in the court, how much they will have to spend. All this is what the mediator explains them, but ultimately it is the parties who themselves have to negotiate the settlement and arrive at a settlement which is to their own satisfaction. That is why once a settlement is arrived, mediation is considered as one of the most successful and most satisfying process where both parties have a win-win situation. As I said, in mediation, mediator works together with the parties to facilitate the dispute resolution process and does not adjudicate the dispute by imposing decision on the parties. Mediator's role is both facilitative and evaluative. A mediator facilitates when he manages the interaction between the parties, encourages and promotes communication between them, and manages interruptions and obstacles by them and motivate them to arrive at an amicable solution. Mediator evaluates when he assists each party to analyze the merit of a claim, defense, and assess the possible outcome of a trial. Mediator, being an expert person, employs certain specialized communication skills and negotiation techniques to zero down the differences between the parties and help them in negotiating the terms which is in their best interest. Mediator is supposed to be a neutral person and he is not supposed to take any sides. Mediator therefore has in the process to develop and win over the confidence of both the parties and assure them that whatever he'll do, he will be stepping into their shoes of those parties and will do the best to their interest. Having said this, let us understand what is negotiation. If I go by definition of negotiation in the Webster dictionary, negotiation is defined as formal discussion between the people who are trying to reach out an agreement. It's a process of settlement of conflict between the two conflicting parties. The word negotiation originated from the Latin expression negotiatus, meaning to carry on business. See, the purpose of negotiators, that is to carry on business, is that you negotiate your differences and carry on the business. Don't let your differences come in your progress of business and relationship. What are the features of negotiations? You see, I'm giving you the background, then I'll come to the role of the parties. Negotiation is a focused dialogue between the disputing parties to resolve the point of differences or to reach an understanding. The negotiation is also called a process of bargaining, either for individual advantage or for collective advantage. What does it require? It requires need of two people appear to be incompatible. It is aimed at gaining the advantage for both the contesting parties. It occurs in our day-to-day life in business transactions, legal proceedings, personal situations like marriage, divorce, parenting, social contexts, and many a times the negotiation is used to rebuild and redefine old relationship or establish new relationships. Now I'll deal with the negotiation in mediations. As I said just now, the negotiation and bargain, they are sort of synonyms. Negotiation basically involves bargaining, and bargaining is part of negotiation. Negotiation refers to process of communication that occurs when parties are trying to find a mutually acceptable solution to the dispute. Negotiation may involve different types of bargainings. Negotiation is an important form of decision-making process in human life. Negotiation is communication for the purpose of persuasion. Mediation, in essence, is assisted negotiation process. In mediation, negotiation is a process to back and forth communication aimed at reaching at an agreement between the parties to dispute. The purpose of negotiation in mediation is to help the parties to arrive at an agreement which is satisfactory as possible to both parties. The mediator assists the parties in their negotiation by shifting them from adversarial approach to a problem-solving an interest-based approach. The mediator carries the proposal from one party to other until the mutually acceptable settlement is found. This is called shuttle diplomacy. Any negotiation that is based on merit and the interest of both the parties is principled negotiation and can result in a fair agreement, preserving and enhancing the relationship between the parties. The mediator facilitates the negotiation by restoring to the reality testing, brainstorming, exchanging of offers, and breaking the impasses. What are the roles in a mediation process? Now here, before we go into the roles of the parties, let us understand what is the role of a mediator, because we are discussing the mediation as a process. Now, when the parties come to mediator, as you have been told yesterday, in the first stage, the mediator tries to understand what is the dispute between the parties. The understanding of the dispute between the parties is essential for the mediator as well as for the parties. Parties, when they talk to the mediator and give their facts, and when the mediator tries to extract the information from them, at times parties themselves realize that they were missing certain facts and certain interesting facet of their problem. So therefore, the gathering of the facts by the mediator from the parties is an important process of mediation. In the process of gathering the information, the mediator also identifies not only the problem, but also identifies the behavior of the disputing parties to find out what exactly is the actual subject of negotiation to each disputing parties. By understanding this, the mediator as well as mediator in this process at times can also help the parties in understanding the limit of their dispute, the limit of their claim, the outer limit to what they can get and what they cannot get. Mediator, while understanding the problem, also encourages the parties to establish a common goal and a long-term goal. In establishing the goal, the parties who have to then go for negotiation are able to understand what should be the goal, what should be their demand in the negotiation. When the mediator is taking the facts, he is assisting the parties in formulating their propositions before going to negotiation table between them. In this way, by having the separate sessions and joint sessions, mediator tries to narrow down the differences between the parties and make the parties to understand the actual dispute between them and also the way the parties can resolve them. There are we call them in the process of mediation, there are negotiating styles. You see, many of these styles people know, but when you are going to negotiating table, as an expert, mediator, one should know what are those styles, because it is from the behavior of the parties. At times, as a mediator, you may have to apply one technique or the other, one style or the other. So what are the different styles of negotiation? Basically, there are identified 5 styles of negotiation. First of them is accommodating, where the parties are accommodative to each other. The characteristic of this accommodating style of negotiation is I lose, you win. Where a party, you see, is, suppose there is a dispute of relationship. It is a partition dispute between 2 brothers or brothers and sisters or in a family. The parties have, some of the parties have an attitude that, all right, I may accommodate, let me lose a little bit, but maintain my relationship. So in that sort of situation, we call this as an accommodative style of negotiation, where the parties are ready to lose a little bit to maintain the relationship and let the other party have the winning feel. This situation also at times has been seen where a party feels that he is weak, and he, in his weak case, whatever best bargain he can get from the other side by showing that he is accommodative in nature. Then the third situation where accommodative style of negotiation is normally adopted is where one feels that there is no point in resisting because the conflict may go on for a long time, and that may be disadvantageous to the contesting party. Here you see the mediator has a very important role. If the mediator can make the parties understand the value of concession, then both the parties can arrive at at a settlement by negotiation in an accommodative style. The second style of negotiation which has been observed is avoiding style. We call it a characteristic of this avoider negotiators is they say that I neither win nor I lose. You neither win nor you lose. These are the kind of persons who are going to negotiation who do not want to face any conflict. They want to avoid any conflict. They don't want to have any dispute with the other side. Here the role of the negotiator becomes very important. Here the negotiator has to bring them out of this avoiding characteristic and make them negotiate and settle the dispute. The role of the parties, such parties who are trying to avoid a settlement, there the mediator has a very, very important role, because he is faced with parties who are avoiding a settlement. He has to narrow down the differences and make them understand that if instead of avoiding, if they settle the dispute, they will be avoiding the litigation, time, expenses, and their energy into the litigation. The third type of negotiation is called collaborating negotiation. Here, the parties' approach is I win, you win. Means this is a win-win situation, which is in which both the sides are able to solve the problem in such creative ways that both the parties have a win-win situation. Here, the parties have to understand the concern of each other very clearly, and at times they have to think fairly to bring a win-win situation. At times here, the mediators' out-of-box thinking of the problem and giving of solution to the parties definitely comes to their aid, and mediator can bring them to a win-win situation. The fourth form of negotiation is called competing negotiation, where a party has a feel that I have to win and I have to make other side lose. This is called I win, you lose. This is a very peculiar style where a party is overconfident and is having a feeling that it can win the situation. So therefore it should dictate the other side its terms. They are often seen to be very aggressive and sometimes psychotic, hostile, even coercive. Here the role of the mediator becomes very important, because he has to control such aggressive parties. He has to bring down their aggression and bring them to a level playing field where both develops the confidence in each other and negotiate and come to a solution. Last type of negotiation is called compromising situation, where partly a party is ready to give up and other party is also ready to give up. Both are ready to have something and lose something. That is called compromising situation, where both coming to a middle ground are able to negotiate and settle their disputes. So these being the few kinds of negotiation. Now we come to the secrets of negotiation. Here you see the parties who are going to negotiation, after understanding the dispute, after formulating their issues, after formulating how much they can accommodate the other side, the parties have to, how they have to work out a workable solution is another secret which the parties have to develop, and the mediator has to assist them in developing that. The parties, the position of the parties, like I said, if there is a dispute between a family, say on partition of a property, here the position of the parties, that is their relationship, they want to maintain their relationship also, they want to get the best of the possible cake of their share in the property. So here you see the parties who are coming to negotiating table, they have very important behavior. Their behavior is very, very important. Like I tell you an example, what Mr. Sharma told me in one of the cases, that was a case of partition between two brothers. The court forced the parties to go for mediation before the Supreme Court mediation cell. Now, in the separate sessions, Mr. Sharma asked the elder brother, what is the problem? Now, the elder brother told Mr. Sharma that my brother does not respect me. I'm ready to give up extra mile to accommodate my brother who is younger to me, but he should respect me. I have brought him up, I have nurtured him. My father and mother were not there. I looked after him, I brought him up. Now that he has grown up and he is on his own, he is not respecting me. So Mr. Sharma, when he talked to the younger brother, he, without disclosing all these facts, he told the younger brother that whatever it may be, he is your elder brother, you must respect him, you must talk to him. So when the younger brother and elder brother in the joint session met, the younger brother touched the feet of the elder brother and said him sorry. And the elder brother said, whatever you want, whatever way you want, let us settle the issue. And the matter was settled. So a dispute which was going for over 10 years got settled because of the behavior of the party. So this is how the behavior of the parties becomes very important. And this is how a mediator, after understanding the problem, can resolve it by bringing the parties to through their behavior. You see, when a mediator is negotiating, often it is believed that the mediator or the negotiating parties should never come to a situation where they say, you take it or leave it, I cannot do anything more than this, you better go back to the court, you will repent for not agreeing, etc., etc. These are the kind of attitudes by which the negotiations normally break. So the parties who are going to the negotiating settlement need to be accommodating, not adopting an attitude of breaking. In the process of negotiation, at times it is seen that there are resistance areas. The parties have certain resistance when they are negotiating. Those resistance areas, if the parties are able to identify, they can discuss with the mediator. Then mediator, by his skills, can suggest the parties the ways and means to break those resistance areas. Those logics behind the resistance can be tested, and the parties can be made to understand how to break the resistance or how to overcome the resistance or why the resistance should not be there. In the process, the resistance in the mind of the negotiating parties can be brought down and they can be made to arrive at a settlement. It is also often seen that in the bargaining, at times, the parties are not able to take a decision because the parties are in a dilemma, whether to agree, not to agree to a particular, say in a money settlement, to agree to a particular amount or not, whether that will be in his interest or not. There again, role of the mediator becomes very important. He can assist the parties in understanding as to what they are getting, whether it will be beneficial for them in long term or not. Therefore, it is very important that the parties who are going to negotiation make proper preparations, go with a positive thinking mind that they have to settle the dispute. Wherever the resistance comes, they need to break that resistance. Wherever the impasse comes, they need to overcome that impasse by discussing it with the mediator, who is a neutral person, who is there to assist them, who is with his experience and special techniques can break those resistance and impasses. It is often seen that when the parties are going to negotiation, they become emotional. The parties have to therefore control their emotions, and the mediator can play a very important role in letting the parties control their emotions and understand the dispute dispassionately and bring them to the problem rather than the personalities. The mediator therefore needs to bring them to their goal, make them understand their interest, and he has to bring a shift in their mindset to take responsibility for the stipulations. At times, the parties start indulging into blame games. Instead of parties adopting the blame game, mediator has to facilitate them to come to from blaming paradigm to cooperative paradigm. At times, the parties were discussing or negotiating with each other becomes angry. It is at those stages the role of the mediator becomes very important. He has to ensure when the parties are angry to defer the mediation, talk to them, bring down their temperaments, bring down their differences, bring down their emotions, and see to it that the stress level because of which they became angry or emotional is reduced, they become normal, and then they can discuss and arrive at a settlement. Once the parties are at settlement, they also need to be made to understand that what are the best alternate to negotiating agreement. That is the role of the mediator. We call it BATNA, B-A-T-N-A, BATNA. BATNA is best alternative to negotiated agreement. It is, you may say in common man's language, plan B. If the settlement fails, then what will be the alternate plan? Best alternate plan. So BATNA is the second plan B, which the parties must be made to understand. Besides BATNA, we also have another term which we use in mediation as mediators, that is called WATNA, W-A-T-N-A, WATNA. WATNA we call is worst alternative to negotiative agreement. The parties also need to understand that what is the worst alternate to negotiated agreement. Means what worst can happen to a party, say to a plaintiff or to a defendant, in case they go to the court, in terms of time, in terms of the result in the case, in terms of expenditure they may have to undergo, in terms of risk factors, in terms of other priorities, etc. So parties have to also be made to understand what is WATNA. And last we called is MALTANA. MALTANA is where most likely alternate to negotiated agreement. That is the most possible outcome that a party can reasonably expect at the trial if the matter does not get settled in the mediation. So BATNA, WATNA and MALTANA, once are made to understand to the negotiating parties, they can understand what will be the implication in case they will have to face the trial and go to the court of law. Last of all, mediator must make the parties understand what is we call as reality testing. It is here, you see, the mediator tests, applies his techniques to the parties and keeping their perceptions behind their back. In the reality testing, the mediator assists the parties in differentiating the actual facts and their perception of facts. The parties are projected with the real actual scenarios. The parties are made to understand the strengths and weaknesses of their cases, which may make them to take realistic stand. The tendency of disputing parties to work with the imagination in their mind is really need to be discouraged, and what can be the reasonable expectation is made to be known to them. It is in these circumstances that when the parties, with the help of Bhatna, Vatna and Matna, are made to understand the real picture, the parties at most of the times are able to, after understanding the real picture of their case, able to settle the dispute. So this is what is how the negotiation in the mediation plays the role. If I have to put at the end, I will say that negotiation is the heart and soul of the mediation process. This is the real test in the mediation process. I will end by saying negotiation is like when two parallel lines are going. Until and unless the parties will make to bend those lines, they will not come together. They will keep on going parallel. The negotiation is a process by that you are making those two parallel lines to move to each other in order to become one line. That is negotiation. Thank you very much.
I may request to...
Anjali, we can take the questions from the chat box.
Okay.
First question is from Krishna Rastogi. Krishna, you can unmute yourself and ask the question.
Okay, sir. Good evening, sir. Sir, my question is...
Krishna, I request you to first introduce yourself.
Sir, my name is Krishna Rastogi. I'm a third-year law student pursuing law from Law College, Dehradun, Faculty of Uttaranchal University. And sir, my question is, sir, although mediators are highly skilled individuals, but when they are appointed by courts, are there any background checks being run so that the courts may know that the mediator does not have any kind of connection with the mediating parties, so that even the slightest chance of biases is eliminated?
Krishna, it's a very good question. This is the basic feature in a mediation is the neutrality of the mediator. The neutrality of the mediator is the cornerstone of the success of the mediation process. When, as a mediator, a case comes to us, the first thing in the introduction, we introduce the party ourselves, and in that we tell the parties that we do not have any interest in the party. It is the, you see, the professional ethics of an advocate as well as the mediator, that he will never try, he should never try to withhold any information, especially if he is having any interest with any party, or in any dispute. In case he has, it is the duty of the mediator to, in the very first instance, disclose or at any stage in the mediation, whenever he comes to know that he has any connection with any party or with the dispute referred to him, it is his duty to disclose it to the parties and withdraw from the mediation process. As it is said that your reputation as a professional is your earning of life, no advocate worth the name of the salt or no mediator worth the name will ever try to withhold any information and spoil his name. We are thorough professionals, and as a professional, we will never like to lose our integrity, our reputation.
Thank you, sir. Thank you.
You may now ask Hamdan for his question. Anjali, unmute yourself.
Yes, yes.
You may ask now Hamdan to post his question. Hamdan has requested you to post his question on his behalf.
Sir, he's asking, does the 5 style of negotiation is in line soft, hard and principled negotiator?
Sorry, I couldn't get the...
He's asking, sir, does the 5 style of negotiation is in the line soft, hard and principled negotiation?
That is from Marisport. Sir, I'll repeat the question. That is in chat box. Hamdan's question is, you said that it is important for the mediator to understand the facet and details of the problems so that he can assist parties in arriving at a solution that creates a win-win situation for both parties. In order to understand the facet and details of the problem, isn't it the mediator should also be familiar, being expert with the subject area of the dispute? For example, construction dispute can be better mediated by a mediator who has some qualifications and experience on construction process project.
You see, mediator is a trained, specialized person who has the special skills in bringing the parties to a amicable settlement. Now, insofar as having special skills about a particular subject or special knowledge about a particular subject, as you said, like in the case of construction industry, if there is a dispute, knowledge will be required or specialized mediator will be required who can understand the nitty-gritties of the construction work. To my mind, it may not be very necessary, because the mediator, when he is interacting with the parties, he will be understanding the dispute and the facts from the parties. And it is on those facts and understanding that the mediator will assist the parties. It is ultimately the parties who themselves have to negotiate. Mediator is neither negotiating or interacting on behalf of the party with the other party. He is only ironing out the differences between the two parties and bringing them closer to arrive at a settlement. His role is not of an expert to understand the subject. His role is of an expert who can narrow down the differences, the impasses and the resistance between the parties in the settlement of the disputes. I don't think that a special knowledge in terms of specialization in a particular field will be required for a mediator to mediate a particular type of commercial or matrimonial or say banking disputes, etc.
Over to
Sir,
you, Anjali.
The next question is, does the 5 styles of negotiation is in line with
Anjali, ask the participant to ask. If they are not, if they could not, then you are supposed to ask.
Okay.
Hello. Hello. Am I audible?
Yes.
Hello.
Marisport, you are
Yes, sir.
audible.
Good evening, sir. This is Marisport from assistant professor from Gujarat National Law University. Good to listen your speech, sir. It was wonderful explanation. Sir, I have two queries. One is, does the negotiation styles, 5 types of styles which you have pointed out, is it in line with the soft, hard principle negotiators which Robert Fisher and William Urey pointed out in their books? And the second one is, does the mediator has the obligation to alter the states of the negotiating parties for ensuring the equanimity amongst the parties?
No, I missed the second point. Can you repeat the second question?
Yeah, the second question is, does the mediator has the obligation to ensure to alter the negotiating styles of the party for ensuring the equanimity of the parties or equality of the mediating parties?
Yes, these are very good questions.
Thank you, sir.
As I said, these are not 5 stages of negotiation. These are 5 types of negotiation. You see, as I said, these are the different styles of negotiation where the parties are negotiating. If a party is in a, like I said, is in a giving up mood, is in a compromising mood, or is in a aggressive mood. So these are the 5 types of negotiation styles which the parties normally adopt. And at times, you see, as a mediator, you have to understand what style party is adopting, so that you can, when you are dealing with them, you are able to handle accordingly. These are in line with the mediation process. There is nothing, these are useful understanding, you can say, of the psychology of the parties when they are into negotiation. These styles are also dependent upon the psychology of the parties. The second question which you have asked is, kindly repeat it.
Yes, sir. Sir, second question, does mediator has the obligation to alter the styles of negotiating parties for ensuring the equality amongst the parties in mediation?
No, you see, as I said, mediator has no role. His role is only assist the parties. He cannot change the terms of negotiation. He cannot force one party to negotiate in a particular manner. He can only explain to the parties that the approach which you are taking, you may need to reformulate your approach. You may need to change your understanding for this reasons, and the mediator can only make them understand. He has no authority to change the terms or or force them to change the terms. He is only a facilitator. He is in no terms to dictate anything.
Okay, sir. Thank you, sir. Thank you, sir.
Over to you, Anjali.
Next is Ayaan Khan.
Right.
Hello.
Ayaan Khan, you
Ayaan
may
Khan,
post your
you
question.
can ask question.
Yes, ma'am. Thank you, ma'am. Khan Yusuf from ILS Law. Yes, sir. Sir, am I audible?
Yes.
Yes. I'm Ayaan Khan Yusuf
Yes,
from
Ayaan.
ILS. I'm a 4th year student from ILS Law College. So my question is that in your lecture right now, you said that the mediator should give the benefit of an offer coming from one side to the other party. So in a situation where the party to whom the mediator is giving these benefits sees this as a bias of the mediator. So like if they presume the mediator to be biased because that person is giving the benefits of the other party's proposal, how should the mediator deal with this problem in case such a thing happens? Should I?
As I said, you see, the mediator is not negotiator. Let us understand, mediator has no role in negotiation. The parties are negotiating themselves. At the best, mediator's role can be if one party tells him that this part of my offer you can give to the other party, then on the instruction of one party, he can disclose that offer to the other party. You see, the mediator is a person with whom parties in confidence can discuss or understand their offer or implication of their offer, but mediator is not supposed to inform the other party until and unless he has been instructed or told to do so. So mediator has always to adopt an approach of neutrality, and he cannot of his own negotiate or change the terms of negotiation.
Okay. So the mediator cannot give any benefits of the other party's proposal. So like if the party has given a proposal, so they cannot give a reality check saying that this is a very good proposal and like these are the benefits that you can have from this. This is the short-term benefit. This is the long-term benefit. This cannot be done.
No, as I said, if the party who is giving the proposal, you see, he is reposing confidence in the mediator and wants to understand from the mediator what are the implications of this proposal. He can certainly discuss and understand with the mediator. There is no harm in that. But mediator of his own will not disclose this conversation with the party to the other party because mediator is supposed to maintain the confidentiality. So he is not supposed to inform the other party until and unless the party giving the instruction that this part of my proposal you can discuss with the other party.
Okay, sir. Thank you.
Anand, please ask your question.
Thank you, ma'am. Sir, I have a question that is in cases of contract where the time is the essence. How does the mediator approaches such kind of cases, sir, where the time is the essence, so he has to resolve all the disputes at the earliest, so that the subject matter of the contract.
You see, where time being essence of the contract is seen as one of the factors when parties are negotiating amongst themselves with the help of the mediator, the time becomes a very essential factor in arriving at the settlement. You see, because of the time constraints, at times the parties adopt the approach. And here you see, if an out-of-box solution is given by the mediator to both the parties, which becomes acceptable to both the parties, then that skill or specialized skill of the mediator helps both the parties in arriving at the settlement.
Sir, one more. Anupriya, please can ask. Anupriya, are you hearing me?
Anupriya, please unmute yourself and ask your question.
Hello. Good evening, sir.
Ji, Anupriya ji, good evening.
Sir, we know that mediation is a confidential method, and if a mediator does not respect one's personal information, then what are the legal consequences of it?
You see, normally I have not come across any such case till date. Mediators are highly professional people, and they will never like to have any bad name. It has not come to my, at least to my knowledge, a case where the mediator has tried to conceal, because you see, it is not one-day process. Your reputation is built step by step. It is like an advocate or any other professional. If you will do one wrong, you are out of your profession. It is like they say, if you are driving a car, one accident and you may finish. Nobody will like to finish his career for a small, because that is the earning which you have, that is the reputation you have, that is all you have as a professional. No professional will ever like to spoil his name.
Thank you, sir.
Sorry. So last is Shell Bala Tripathi. Shell Bala
Good evening,
Tripathi.
sir. Hello.
Good evening, Balaji. Good evening, Shal Balaji. Good evening.
So my name is Shalbala Tripathi. I'm a fifth year law student from Department of Law, Calcutta University. My question is, if at any point of the case, any of the party feels like withdrawing or to go for some other mediator, are the parties in the position to terminate the session and go afresh with a new mediator?
You see, normally these kind of situations are not seen because ultimately it is the parties who are negotiating, not the mediator. Mediator is only assisting the parties in arriving at a solution. I don't think that the parties normally will have any grievance against the mediator and will like to change the mediator, because it is they themselves who are negotiating, not the mediator. That situation is not seen. That is why we say that, you see, we have to win the confidence of the parties by showing your neutrality, by showing your candidness, and by showing your confidentiality.
Anjali, we can take last question also.
Okay. Aishwarya Gandham. Aishwarya Gandham, you can ask. I think she's not there.
Okay, you may ask on his behalf.
Good evening, sir.
Yes, good evening, Aishwarya.
Sir, in case of death of one of the parties in the mediation, will the mediation cease or will it continue with the legal representatives or the legal heirs?
Yes, mediation, in case you see the party has died, the mediation can continue with the legal heirs. There is no difficulty in that.
So what if the legal heir goes in a different, goes for different terms than the ones that have been arrived at previously?
You see, once a settlement has been arrived at and signed between the parties, then legal heirs are bound by that, because legal heirs are only stepping into the shoes of the person who has signed the settlement. Once it is settlement has been arrived, once the settlement between the parties has been arrived and the mediator has penned down, got it signed and sent to the court, then thereafter those terms of mediation, terms of settlement cannot be changed.
Thank you, sir.
Anjali, I request that one very interesting question has been posed by Deepika Sharma, if you allow her.
Yes, please.
It depends on...
Good evening, sir.
So yes, Deepika ji, good evening.
My question is, in a case where one party admits or confesses about his offense, any criminal offense he has committed in the past, can the mediator then be called in that case? And what about the principle of confidentiality in the mediation process?
Sorry, you'll have to repeat, your voice is cracking.
Okay, sir.
Anjali, you please ask the question on our behalf.
Sir, in case where the party admits about any offense committed by him, can mediator be called as witness in that case?
No, you see, whatever you have disclosed to the mediator during the mediation process is confidential. Mediator cannot be called as a witness in evidence.
Can I ask a follow-up question to that?
Yes.
Sir, in case if the mediator declares while the when the mediation process started, before the process started, if the mediator declares that my liability, there would be no liability on my behalf to the any towards the any criminal offense or anything like that. So, in that case, can we call mediator as a witness?
See, as I said, mediator is not liable to be called as an evidence or as a witness. He is not liable to be called in as a witness.
Okay, sir.
You see, like, let me give you an example. Between the client and the advocate, there is a confidentiality clause. So if the client discloses something to the advocate, the advocate can't be called. He can refuse to divulge that information because that is confidential. Similar is the situation with the mediator.
Okay, sir. Thank you.
Yeah, very good question.
Thank you so much, sir. I may request to my colleague. I may request to Sanpreet Singh propose a vote of thanks, please.
The toughest task today is for me to propose the vote of thanks. Since both the speakers, the moderator as well as the speaker, they both are so humble and so close to me. And I admire most both of them in Supreme Court. So, since Anjali has already spoken about sir and rightly said, sir is most humble person and very kind, even to young lawyers. And I'm delighted today to have my mentors today instead of saying speakers. And it was indeed a wonderful session. We have now come to an end to our 4th class. Tomorrow's session would be taken by Senior Advocate Mr. Rajiv Datta. The information regarding the same
sorry to interrupt. The session tomorrow is with Lady Justice Joyce.
Oh, I'm so sorry. I missed it. Tomorrow we have an international session. In fact, tomorrow the session would be by Lady Justice, and I request all the participants to communicate it to all their friends who have missed today's session. So we have 90% attendance today also, and I hope that the same remains. And thank you, Rahul, so much for correcting me. And it brings an end to today's session. It was extremely well. Thank you so much, Khanna sir. Thank you so much, Anjali Chauhan, for moderating today's session so well. And thank you, the participants, to be so vigilant. And I request the participants to be vigilant, more vigilant, so that they may put their questions and we may educate from their questions.
Yes.
Thank you so much.
Thank you, Anjali. Thank you, Sanpreet, and thanks to everybody. Bye.